This instruction is showing up. So sure.
Might say, just go and get the responsible for something later on.
Send this way up.
Okay. I'll get it for you. We're all in there. can't get started. He can just,
Yeah, I'll tell the lady at the desk when he checks.
then he,
That's great, thank you.
okay. So you don't need to come to the podium. You can all sit at your tables. This is State of Ohio versus Derek Weed.
Your Honor, Ellen's coming.
Oh, sorry, Ellen, I didn't even look for you. Sorry. Okay, State of Ohio versus Derek Wheat, Maurice Glover, Eugene Johnson, 324-431. They're before the court today with their counsel, Mr. Nazo, Mr. Murner, and Mr. Howe. The state is also represented. The court has received a motion from the defense for relief pursuant to Rule 60B and a dismissal with prejudice, petition for post-conviction relief. The state has responded. Is there anything the defense would like to say in support of their motion?
Yes, Your Honor, briefly. In March 2015, the court found the state had suppressed evidence that could have led to the exoneration of the defendants in 1995. That conviction was vacated. The decision was upheld by the 8th District Court of Appeals, and the case was set for due trial. Since that time, through a diligent and exhaustive investigation, defendants have found that the material subject of the Brady violation is largely lost forever, and defendants argue that has permanently and irrevocably deprived the defendants of the opportunity for a fair trial in the future. As such, they've asked the court to bar the state from retrying under the constitutional theory that the state has lost the evidence pursuant to California v. Chormata. The state's primary argument is that the court can't consider this. In fact, the petition for post-conviction relief remained pending before the court. There's been no finding. There was no final ruling through the appeal, as was evidenced by the state's request for a final ruling with the appeal pending back in March of 2015. No findings of fact, no conclusions of law have been issued on the petitions for post-conviction relief. It is well settled that until findings of fact and conclusions of law have been issued, the petition for post-conviction relief remains pending and remains open to the court. It is not appealable. As such, it's open to amendment, open to revision, open to finalization. Furthermore, petitions for post-conviction relief do give this court authority to dismiss the case with prejudice. Under Revised Code 2953.21A1A, the court has the authority explicitly to vacate the conviction and to, quote, grant other appropriate relief. In addition, under Revised Code 2953.21G, the court has explicit authority to grant, quote, supplemental orders regarding retrial, including presumably to bar retrial. If the petition for post-conviction relief is not pending for some other reason, if it was dismissed along with the dismissal of the case in August, it would presumably be a final appealable order, to which Civil Rule 60B will apply per state v. Schlied from the Ohio Supreme Court. Defendants and subject to review and revision by this court. Again, the main issue before the court is the constitutional one, in our opinion. Under State v. Chambetta, the evidence that the state failed to disclose in 1995 is now largely lost to defendants forever. That includes specifically, and pursuant to the affidavits attached to the defendant's motion, in 1995, Dante Petty told police that he could identify the shooter as the sibling of one of his classmates. That information is now lost forever. Gary Petty had also made statements to the police, at least according to the reports that were created in 1995. He has no memory now of those reports. Defendants retained a cognitive psychologist to confirm that such lost memories are not subject to bringing it back, and in fact, it is physiologically impossible to recover those memories. And finally, we know today, which we did not know in 2015 and in August 2016, that it's impossible to conduct a meaningful investigation into the Bufford shooting. Defense investigation has been extremely exhaustive and thorough. In short, the evidence that defendants were entitled to is now lost forever. Allowing further trial would deprive defendants of their due process rights in the United States Constitution, allow the state to benefit from its own misconduct. Thank you.
Anything from the state?
Yes, thank you, Your Honor. May it please the court. We would just, first of all, incorporate the arguments we've set out in our brief. The defendants are conceding as I understand it, that the court cannot alter via Civil Rule 60B the actual dismissal. And their argument is that the court should apply the PCR statute, the post-conviction relief statute. Our position is, since the defendants aren't convicted, the PCR statute doesn't have any application, and that there is no pending indictment. We would also add that this court did resolve the PCR. The court resolved it as moot, and that the PCR itself didn't ask for the relief they're requesting today. The remedy in the PCR was a request for a new trial that was granted, and because there is no pending indictment, there is no pending case. The state's argument is that there really is no statutory authority for this court to grant the motion. So we'd ask the court to deny it. Thank you.
Can you tell me, Mr. Miranda, you were here last week, right?
Not at the last hearing. In August?
You weren't here?
I don't know. I was not.
Mr. Radigan indicated to the court at this time it's not the intention of the state to refile charges against the defendants. So, are you intending to refile charges?
No.
So what is the problem with dismissing with prejudice? What is the state's objection?
The state's objection is procedural. There is no pending case.
I understand the procedural part. I'm asking you, why are you opposing the dismissal with prejudice for these three defendants?
And the state's position is that the parties reached an agreement back in August to dismiss without prejudice, and we don't see any legal reason why that it should be reopened at this point.
So is it your intention to never dismiss this case with prejudice?
We're not taking any position. We have no intention of reopening this case.
So again, I'm not clear I understand. As you know, there are collateral consequences for people with a dismissal without prejudice. They can never get the record expunged. It affects their ability to make a living. I also believe it may, I may be incorrect, but I believe it prevents them from seeking any monetary recompense for the time that they spent in prison. So I need to understand, what is the reason? There has to be some reason that you don't want to dismiss it with prejudice. What is the reason?
Your Honor, I think the defendants are eligible for an expungement. If they filed for such an expungement, we wouldn't oppose.
But legally, I can't grant an expungement on a dismissal without prejudice.
No, I don't think that's correct, Your Honor. You can grant it. We've seen case law that says you can grant because there's a difference between a conviction versus sealing an arrest. And we certainly wouldn't object to an expungement if that was requested today.
But you retain the right to refile. So you're telling me, because I've had people with this exact same situation, with a dismissal without prejudice, who sought expungement, and they could not get expungement. So are you telling me that you're not going to oppose a motion to expunge?
Correct. I mean, we certainly have opposed in a discretionary sense, but we would not oppose in this case.
So I still don't have an answer to the question. Why hold on to the dismissal without prejudice? What is the reason?
Your Honor, there's no legal mechanism for the relief they're requesting. These collateral consequences were new in August. The parties agreed to a dismissal without prejudice, and we're simply asking that the court apply the law and deny the motion.
You're not going to answer my question.
I think I have, Your Honor.
No, you haven't. I'm asking you philosophically, what is the reason these three defendants can't get a dismissal with prejudice when we've seen repeatedly the office do dismissals with prejudice? You may have a valid reason. I'm asking, what is the reason?
There's no legal mechanism for granting this relief.
I'm not asking for the legal mechanism. Are you just not going to answer the question?
I think I have, Judge.
Does anybody else think he's answered my question? Do you think he's answered my question, Mr. Howard?
I understand the state's response to be that their objections are purely procedural and not philosophical, but correct me if I'm wrong.
No, correct. We're opposing because there is no legal support for granting the motion.
But you could today decide to dismiss with prejudice on your own.
The state's position is we're asking that the law be followed.
You could you not, today, dismiss it with prejudice if you want?
The
Yes or
state
no?
can't dismiss an indictment that's not pending.
You could. You could agree to dismiss the case with prejudice, just like you're agreeing to expunge it.
No, the expungement statute permits a dismissal without prejudice to be sealed. And that's the state's position is supported by case law.
Are you willing to state to the court today that the state will never seek re-indictment of this?
No.
You're not willing to say that?
No.
Well, then that would be your reason for not changing it. That's all you had to tell me. That would be a legitimate, logical reason why you would tell me you want to leave a dismissal without prejudice is that you may seek re-indictment in the future. Correct?
The state's reason for its opposition is that there's no legal authority to grant.
Mr. Brandon, if you were a witness right now, and someone was cross-examining you, they would get very aggressive. I don't want to get very aggressive with you. I'm just asking you to answer a simple question. Is the reason, I understand the procedural reason, that's what you're hanging your hat on, but you also just told me that you're not willing to say that you will never seek re-indictment.
Correct.
Okay, so that is part of your strategy, correct? That you may seek re-indictment in the case.
In a potential sense, I mean, we certainly have no plans to indict. But the fact that one day an indictment could occur is a reason why we're opposing the motion, correct?
Okay. All anything from the defense?
Good.
Anything correct?
Well, I will say I'm slightly troubled by Mr. Miranda's statement that I guess that they would seek an indictment at any point in the future. And that's really the reason we're here, Judge. You know, we've got 20 years of litigation here, 15 years of litigation I've been involved in, 20 years of wrongful incarceration, and let's not lose sight of the fact that we're here because of a Brady violation, which is a wrongful action by the state of Ohio. And to allow this to continue, to allow the possibility of an indictment coming or the shroud to hang over our clients, there has to be some mechanism somewhere. And I'll find it. If it's not this mechanism, perhaps it's the courts, I don't understand. But to have that above them, it's not fair. You can't have your cake and eat it too. You can't deny evidence. You can't secure what is an illegal conviction, in my opinion, and then still keep out hope that eventually, if something pops up, we're going to re-indict this at some point. I know we had some conversations before we went on the record here, and, you know, I will unequivocally state it was never my understanding that the state of Ohio was going to agree to absolutely dismiss this case without prejudice. Okay, I can say that. I don't remember it like that.
Without prejudice, you mean?
I mean, with prejudice, excuse me. We were moving in that direction once we resolved things in August.
Right, because you wanted to do some additional.
There's some additional research, and, you know, that was a chance in August for some finality to this, too. It's been a long battle, so we certainly talked it out. I'm going to talk with Eugene about what the pluses and minuses of going forward at that point was. But at some point, there's got to be an end to this, and that's all.
How do you all feel about the expungement? The state's indicated they're not going to oppose a motion for expungement. Is it something the three of your clients want to explore?
Yes, I'd certainly look into that option.
Yeah, sure. I'd like to. I would appreciate the opportunity to discuss with my clients.
Okay, I think, you know, though, you have to make a decision because if you want to explore the expungement, then I don't know that it makes any sense for us to proceed on this discussion of petition for post-conviction relief. I think you got to pick which one you want to proceed on. So somebody's going to need to let me know. I'll hold this for now, but if that's what you seek to do, it makes sense that you can't pursue both paths at the same time. All right? So if you could let me know maybe within a week so that I don't have all kinds of lawyers writing all kinds of briefs that they don't need to write. Okay? Okay. Thanks, everybody.
Thanks, Judge.
Kathleen Caffrey, the PIO for the prosecutor's office.
Yes.